Good afternoon, everyone. Thank you so much for attending this month's CJR Scholarship Workshop, Pretrial Justice in Out of the Way Places, including STAR jurisdictions and the bail reform conversation. I'm Malia Brink, a new senior policy attorney with the Deason Center. For those of you who may be new to the Deason Center's CJR Workshop series, these workshops provide a virtual forum for academics and researchers to share criminal justice works in progress with an audience of academics, practitioners, and other stakeholders. Thank you very much for being here to be part of this conversation today. This month's presenters are Professor Jordan Gross and Dr. Laura Kirsch, co-supervisors of the Rural Justice Initiative at the University of Montana. Professor Gross is a professor at the University of Montana's Bletwell School of Law, where she teaches criminal justice in Indian country, criminal procedure, professional responsibility, and white-collar crime, among other things. And sorry, I'm going to shorten up intros and let them get to their presentation very quickly. Dr. Laura Kirsch is an adjunct professor in the psychology department at the University of Montana, where she teaches a variety of courses at the undergraduate and graduate level. Dr. Kirsch is also in private practice as a clinical forensic psychologist, consulting and performing mental health assessments for the criminal and civil courts. I am going to turn it over very quickly. Please welcome our speakers. And Professor Gross, do you want to take it from here?
I will take it from here. Thank you so much.
I'm sorry, one quick thing, which is to say, anyone who wishes to ask a question during the presentation, please put it in the chat. I've been given prerogative to interrupt and potentially ask questions if they're relevant immediately. After the presentation, we will have a Q&A in which people can raise their hands and I can call on people and let you unmute and ask your questions directly. Or if you would prefer that I ask them, feel free to keep putting them in the chat and I'll keep an eye on it.
Okay, well, thank you, Malia, very much for the introduction. And of course, thank you to the Deason Center for the invitation and Kenitra for all your shepherding and guidance in getting us to this point. Appreciate that. As Malia said, this is very much a conversation, so we do encourage dialogue. And so we look forward to getting your input on this. Before we get started, I do want to share a picture with you. This is a picture of Missoula and the area where the School of Law and the university is currently situated in Missoula. So I want to take the opportunity to recognize that the University of Montana does sit on Indigenous lands and just take a minute to share the School of Law land acknowledgement with you. And to share that, the School of Law is situated on the traditional lands of Indigenous people, and that includes the Salish, Kootenai, and Kalispel people. Many other Indigenous people, including the Blackfeet, Nez Perce, Shoshone, Bannock, and Coeur d'Alene, have and continue to have a crucial presence in the area where the law school and the University of Montana are currently situated. We at the law school acknowledge the role of the legal system and the role it has played in the removal of Indigenous people from the lands where the law school is currently situated. And through our commitment to education, service, and scholarship, we strive to improve the quality of justice for future generations. Doing this demands respect for tribal sovereignty and Indigenous cultures, as well as accountability to the needs and perspectives of Indigenous people who from time immemorial to the present and until the end of time protect and remain connected to the land on which we gather, live, learn, and work. So thank you for the opportunity to share that with you. We do try and ground our work at RJI and at the law school in remembering these first principles. Our roadmap for today, I want to take a minute just to orient people to what the Rural Justice Initiative is, what we do, what we're up to. I'll help define the inquiry of the project we're going to present to you today, with the caveat, this is very much a work in progress. That's why we didn't circulate any materials ahead of time. And so this, as I said, it's a work in progress. So we really do invite your input and your thoughts on it. And then I'm going to turn it over to my colleague, Laura, to introduce the project itself, the survey, and let you know the follow-up that we're engaged in. And then, of course, as Malia told you, we'll have some time for Q&A and so your input. So as we're going through this material, as I said, it's not a done deal, it's a work in progress. So we really hope that you'll have some thoughts for us on perspectives we might take, how we might think about some of the data we've collected to this point, and particularly on the next step on our follow-up part of the project. The Rural Justice Initiative came into being fairly recently, thanks to a generous friend of the law school. Laura and I got a little bit of cash to work on some pet projects and to follow some interests that we have. And very importantly, we were given an opportunity to, as I said, to have a little bit of money to work on some things that we're interested in. So our primary focus at RJI is collaborating with our local, state, tribal stakeholders to support evidence-based criminal justice policy with a specific focus on rural and indigenous communities. In our observation, those are communities that are often left out and overlooked, not by this group at the Deason Center, of course, but generally in criminal justice reform. So it's our hope to just kind of hold that up and shine a little bit of light into this area of criminal justice reform. I want to take a minute to introduce our team. There's, of course, me and Laura, two of our research assistants. That's the great thing about being able to do this, is we're able to offer graduate students some research assistant positions to help us do this work and give them some experience in criminal justice reform research. And so our current RAs, we have two of them. We have Sebastian Coombs. Can you raise your hand or at least wave, Sebastian? And Tori Hill is here as well. Tori is a 2L student at the law school, and Sebastian is a graduate master's candidate in the math department. We are an interdisciplinary team, and Gabriella G is not with us. She is a PhD candidate in the psychology department. And a little shout out to Joy Barber. Joy, I see you there, a recent graduate of ours who is one of our former RAs. So that's the cool thing about what we're doing. We're able to assemble an interdisciplinary team and work with our graduate students to do some of these projects. So our current projects, Laura and I teach an interdisciplinary criminal justice reform class that includes graduate students from multiple departments at the university. Very much a labor of love. We put this on top of our full-time jobs, and we absolutely love it. Both of us are very committed to interdisciplinary criminal justice reform. That's the only way I think that we're going to get workable solutions to some of the issues faced in our communities. And our current focus is on pretrial detention decision making. There's only two of us, so we've got to focus somewhere, and that is our primary focus, and I'll explain why. Our current project that we're going to talk to you about today is a survey that we recently conducted of Montana state trial courts, decision makers around pretrial detention. And future things, these are things we have in the hopper. We would like to take this survey and do the same thing with some of our regional tribal courts. And we do want to focus at some point very deeply on what we call border towns. So those would be towns that straddle Indian reservations. We have a number of those in Montana, and that matters because of the very complicated rules around criminal jurisdiction in Indian country, that we might have justice involve folks who are have matters going on in a county court and also in a tribal court, and that might involve pretrial detention. So really thinking about those specific populations. And some point, because we are very ambitious, Laura and I, even though we have too many things to do, we're hoping at some point to establish an Intermountain West collaborative around some of these issues. We have some states that are a lot like us, as some of our neighbor states and Alaska. And one thing that we share in common is we are low resource states, and Laura and I are always very interested in leveraging resources. So that's an invitation to anybody out there who might find yourself consider yourself one of our neighbors. That's something we hope to be able to do, to set up at some point an interdisciplinary, just a way to exchange information and research in this part of the country. All right, that's what we're up to. So why pretrial detention? Why are we focused there? As I said, there's only two of us, but we also have a substantive reason why we're focused on pretrial detention specifically. In our experience and observation, is one of the most consequential decisions in the criminal justice process. whether you are detained or are at liberty awaiting trial, can have, as probably everybody on this call knows, very significant downstream consequences on so many levels. And also, just from a substantive perspective, pretrial detention and bail is one of the areas in American criminal justice where there's the most variation. It's one of the few areas of criminal procedure that has not been federalized through incorporation. And that's because under the Eighth Amendment, federal Eighth Amendment, there is no right to bail, whereas in many states, including Montana, there is a constitutional right to bail. So this has led to a wide variation of practices, both among and between jurisdictions. And I think that's another reason why it's particularly worthy of specific attention in specific jurisdictions. There is absolutely no one size fits all in bail reform. Oh, okay, so that's why. And then a couple of things as by way of background. When we're thinking about why are we interested in rural and indigenous and tribal court jurisdictions, modern bail reform is, I think, driven and defined by a number of characteristics. One is resources. It's a little bit easier to get rid of cash bail when you have robust pretrial services and professional pretrial services. That's not something that low resource, low population, spread out jurisdictions have the luxury of providing often. We don't have a lot of professional pretrial services in Montana. Compare that with, for example, the federal system, which does have an entire agency built around pretrial detention. Another thing that characterizes a lot of modern bail reform is algorithmic justice. We'll talk a little bit about that and how that's used in Montana. But one thing that in our observation is that algorithmic justice does not always take into account rurality and indigeneity. And so we have a question around that is, to the extent that rural and Indian country jurisdictions are worthy of separate attention, that might be one reason. And a lot of, criminal justice reform particular is focused on, the research is focused on urban jurisdictions whose demographics might be a little bit different. So, here's our inquiry. So what about rural and Indian country jurisdictions? What about indigeneity? How does that factor in? One thing that Laura and I have observed in a lot of social science and legal research is often the demographics that are shown in the research do not include Native Americans. Very often the population is absolutely completely erased, if you will, from some of the research. And then another inquiry and focus of ours is do different resources and relationships. So we know resources and relationships may be very different in rural and Indian country jurisdiction. Does that matter? And to the extent it does, can we even measure or capture that? This question about algorithmic tools, should they account for rurality, for indigeneity? We know that some jurisdictions don't use some of the tools that are available. Alaska is one of them, for exactly this reason, because the demographics are quite different. And then really what should always be the focus is what support do rural and tribal jurisdictions want or need? And so this is a space that we're hoping to help inform. Foundational question for us, and probably for many people on this call, is, so what is rurality after all? It's a very inexact term, and I just want to acknowledge that can mean very different things to very different people and different organizations. It depends on your metrics, right? Sometimes we look at proximity, connectiveness, shared political boundaries with an urban core, population density, size. The federal government has no fewer than 8 primary definitions of rurality. So if we don't have a shared one, we're in good company. One example is the Census Bureau. The Census Bureau says something rural is anything that's not urban, which, I'll show you some maps in a minute. It doesn't help us a lot in Montana because we're considered a very rural jurisdiction, but we have little pockets of what some people might consider urbanity, not somebody from Los Angeles, but what we might consider urban. So it's a mixed bag. And I think that is worthy of our attention when we're thinking particularly about bail reform. And this is just some census definition. Urban includes urban areas, urban clusters. So we've thought a lot about this, and we're still thinking about that. I'm not sure we've landed exactly on what we mean by rurality, but here's why it matters. Depending on what definition I use, I might have a big swing in how many people in the United States are considered rural. And why does that matter? It might skew the relationship, right? If I'm trying to evaluate what resources are available in a rural community, my metrics might give me a different outcome, right? I might get a different picture. But most importantly, we know that there's a lot of criminal justice reform is grant funded and funded by programs. And so this can impact the allocation of research and resources if what we're trying to do is mitigate disparities among justice-involved populations. I think it really is important to make that evaluation. So I'm not here to tell you we've landed on a particular definition, but I'm going to show you how that plays out in Montana when we're trying to think about what is rural and where our focus should be. So there's two ways to think about rurality. One could be geography. So of course, Montana is the fourth largest state by land mass, right? We are spread out. And another metric we might look at is population. So when we're thinking about who are our peers, who should we compare ourselves to, who can we learn from, and who can we help investigate, we're sort of thinking of our peers as those other large states with low populations or lower populations. So except for Alaska, we do consider ourselves neighbors with Alaska, even though technically we're not neighbors. We have a lot in common. But thinking about in those metrics, it's really kind of the Dakotas and Wyoming. We're very similar in a lot of ways. We don't have a lot of resources. Each one of those states only has one law school, very few universities. Alaska doesn't even have a law school. So thinking about concentrating research and resources and attention, we do think that these are states that do need to think about how we can collaborate to leverage our resources because we don't have a lot of them. All right. I want to give you next, I'm going to walk through a series of maps just to orient you to our project and show you literally our landscape in Montana. So in Montana, we have 56 counties, and we also have 8 tribal nations, 7 of which are land-based, meaning we have 7 Indian reservations. We do have one tribe, the Little Shell tribe of Chippewa Indians does not yet have a reservation, recently received federal recognition. And so one thing you might notice too, when you look at that is most of our reservations are bisected by county boundaries. And that does come to play a very large role when we're talking about those border towns, when we're talking about justice involved individuals. They may be in 2 different judicial districts as well. So for a lot of historical reasons, our Indian country boundaries do not overlap with county or even voter districts in Montana. All right, so that's kind of our landscape. And then I want to show you this map. These are our county maps, and this is an overlay with our judicial districts. So unlike, I know a lot of states, particularly more populated states, there will be 1 judicial district per county. That's not us. We have our 56 counties and 22 judicial districts, and they sort of track population, not perfectly. But we're small, we're few. We have 46 district court judges and about 110 pretrial decision makers. So we have justices of the peace, municipal judges, city judges. So not a lot of folks making these decisions, which is good or bad from a research perspective. But this is how our county and our judicial districts are set up. So one thing you might observe as well is some of our larger districts geographically, like 16 and 17, are very low population. And we might have one judge writing circuits. Not every county has a jail. I know in more populated states, every county has a jail, and that does impact pretrial detention. If you don't have somewhere to put somebody, or if it's going to cost a lot of money, you got to get the sheriff to transport them to another county for detention. That can play a big role as well. All right, so that is part of our landscape, part of what we're our situation here. This is the U.S. Census Bureau map that indicates Montana's population density. The U.S. Census Bureau does consider us completely rural, but then, as I said, there's rural and there's rural. So if you look at the map, you'll see the green is federal land. The yellow is where there's hardly any people, and then we have the higher concentrations of our population around some of our cities. And finally, we're going to bring this all together. There's a shout out to our RA Sebastian. Everybody should put a math graduate student on their research team because he does cool things with maps. All right, so this is bringing it all together. As I said, the shout out Sebastian, well done. It shows you the boundaries of the Indian reservations, our judicial districts, and you can see that kind of Pepto-Bismol color. That is a moderate concentration of population, and then that darker red is where our population centers are in Montana. And this is going to come into play when we talk about who's doing what in pretrial detention practices in Montana, because it's not consistent in our state. We have our population centers are doing one thing, and our rural counties and jurisdictions are doing something a little bit different. Okay. All right, I'm done with my map show and tell. So these are the things we're thinking about when we're talking about resources and relationships. Of course, when we are thinking about rural jurisdictions, it's different resources with respect to infrastructure, transportation, internet, cell service, the same things, the things that might help support robust bail reform in more urban jurisdictions may not even be here. So things as simple as like cell phone text reminders to get you to your court appearance may not be an option if you don't even have cell coverage. That is an issue for us. Transportation, how are you going to get there, right? We don't have a lot of public transportation outside some of our cities. Basic needs, housing, healthcare, mental health counselors. If the idea is to keep, and hopefully the point of bail reform is to incarcerate and detain the smallest number of people possible, well, what are you going to do? It's great if you have a lot of resources, mental health resources, pretrial services, housing, alternative housing for people, but many of our rural jurisdictions simply don't have those resources, not a lot of alternatives. And then legal resources. Lawyers, we do have an access to justice crisis in Montana, where there's plenty of lawyers in our population centers and very, very few in some of our more rural jurisdictions. We have very few professionalized pretrial services agencies. Not every county has a jail, and we don't have a lot of non-carceral supervision options. And how about relationship? Rural communities are often defined or characterized by what Freudenberg called density of acquaintanceships, meaning people know each other, right? So a large degree of physical privacy, but low social privacy. And Laura and I wonder, well, how, if at all, does that play out in the bail and pretrial decision-making context? So we may have a judge who actually knows almost everybody who comes in front of them, and probably knows several generations of justice-involved people. That could be good or bad, right? It could be a good thing if I know your uncle and I'm willing to release you to your uncles let your uncle be your surety or your aunt be your surety, but that might have a negative connotation as well, a negative implication as well. If I know you and I know everything else you've been up to, and I have a negative perception of you or your family or your social circle, so how, if at all, can we even measure that? But we do know that in rural jurisdictions, people know each other and people know each other's business, and that may or may not play out in the bail context. And then something that does play out in the rural context is less support or even suspicion of government programs. So if the idea of bail reform, one of the backbones of bail reform is more government programs, right? More involvement, more interface with government agencies. whether it's through GPS monitoring or nonprofits that have outsourced to whom the government has outsourced supervision. What does that mean, and how does that impact that as well? And then in Montana, we're going to throw in the weather. We do have communities that literally can be completely isolated during the winter with the big snowstorm. So how, if you're thinking about releasing somebody and you can't supervise that person or even reach them, that may have an impact. And as I mentioned, just our connectivity. We do have places in Montana where there's no broadband access, no cell phone service. And so remembering that a lot of bail reform does rely on technology, and that may not be a fit for us if we don't even have that technology in place. All right, a couple more, and then I'm going to turn over to Laura. I want to talk to you about Montana bail and pretrial detention, just the legal structure. As I mentioned, we are a constitutional right to bail state. That means we have no preventive pretrial detention outside of capital cases, period. So what we do use cash bail in Montana because that's the only way we can detain people who are non-capital defendants who we believe to be too dangerous to release. And so like many constitutional right to bail states, we might use unpayable bail, right? If we have somebody accused of a very violent offense, they are entitled to bail. So we'll set it at, $500,000 or $250,000. And that way we can get our preventive pretrial detention. But as many people on this presentation know, a lot of states have had to make that trade-off. If you want preventive pretrial detention, you have to amend your constitution to allow for it. So unlike the federal system, you cannot be detained without bail in Montana, except for capital offenses. We have a comprehensive bail statute like every other jurisdiction. The decision is made must be made at the initial appearance. As a little nod to our rurality, we do allow for remote appearances. And often that means somebody is appearing from jail. So the social scientists tell us that you fare less well if you are appearing remotely. And we do use those remote appearances, so it can be a double-edged sword for sure. Appointment of counsel is not required in Montana. It's true of many jurisdictions at the bail hearing, and this is what our statutory law says. There are some enumerated factors that the trial court must consider, and they're the things that you would expect trial courts to have to consider: the nature of the offense, the defendant's criminal history, a whole list of things that have to be considered. And then recently, we amended our law in 2017 to say trial courts in Montana may, not must, use a validated pretrial risk assessment tool. In states that have gone with preventive pretrial detention, like New Jersey, some states have mandated the use of the validated risk assessment tool. We can't do that in Montana because we're a constitutional right to bail state. So that's kind of how it walks hand in hand with our constitution and our laws. And validated, maddeningly, is not defined in the statute. So it can, we'll get to that. It can mean a lot of different things, but we have not defined that for statutory reasons. All right. In 2017, we changed the law to allow consideration of the validated pretrial risk assessment tool. And in 2019, the legislature reauthorized and funded a pilot program, which I'm going to describe to you in a minute, that is run by the Office of the Court Administrator, is a group that we collaborated with in our survey, and that is it's a branch of the Supreme Court of the state of Montana. And so this is what bail reform looks like right now in Montana. The pilot project included 5 counties originally, now includes 7, which doesn't sound like a lot if we've got, 56 counties, but that covers 80% of our population. So that's how this plays out in Montana. When I'm talking about bail reform, it has focused and concentrated on the population centers, leaving the rest of the counties out there. One county, Gallatin, uses its own pretrial risk assessment tool, came up with its own thing. The other ones are the Arnold tool, the PSA that is provided by the Arnold Foundation. So in Montana, though, it has its own little twist, which is the PSA, the Arnold PSA, plus a decision-making framework that was created in-state, in-house by it included defenders, prosecutors, judges got together. So that's how it works, right? So it doesn't change anything about the Arnold PSA. It kind of sits next to the Arnold PSA. The PSA is calculated centrally by just a couple of people. So what happens is trial courts, again, that lack of resources, right? The lack of concentration of resources is the trial courts gather the information and then they send it to the pilot project group. The PSA group, they calculate it and then they give it back to the decision maker within 24 hours or 48 hours of the arrest. There have been some complications and considerations. One is just data collection challenges. Montana, like many states, does not have uniform collection or centralized reporting of criminal justice data. We know who's in our prisons, but not in our jails. We have some legislation that passed recently trying to address that, but we don't really know who's in our jails. So while we're doing this bail reform, there's no companion tracking of jail populations because we simply don't have that infrastructure technologically in Montana yet. And then COVID, right? COVID comes along and a lot of trial courts change some of their detention policies to try and reduce the numbers in jails. And we know that worked, and but many jurisdictions are back in Montana and other places back up to their pre-COVID numbers. So that might have thrown it off a little bit. So that's the pilot project. For people on this call, I want to just draw your attention to kind of this PSA site. So this is what my point about bail reform being so localized and why I do think this is worthy of individual jurisdiction attention. So if we look at this, we do have a couple of states, New Jersey, Kentucky, Arizona, Utah, that are using a PSA statewide. And that's probably because of the change in law in New Jersey, excuse me, was at the forefront, right? They changed their constitution, allowed for preventive pretrial detention. And that means you can use a PSA, right? If you have no right to bail, then you can rely entirely on some sort of algorithmic tool. We can't do that in Montana because of our right to bail. And then you see that some states, some counties have adopted it, but we don't have any uniformity in the United States, which I have no value judgment on that. I just think it's ripe for research. And so because we have researchers on the call, I want to point this out to you, because there's a lot of good comparative research that can and should be done, particularly in this arena. So finally, just a couple more things on, remember I told you about that decision-making framework that sits in Montana next to the Arnold in the 7 counties that are using it, which covers 80% of the population. What it does, it gives decision makers a framework that is permissive, discretionary, it is not mandatory. So we have, even in those 8 counties, individual judges who may or may not use it, right? Who may or may not be using the tool. So this is the framework that is recommended. The first question, of course, is release or temporary detention. And that first decision point, because we are a constitutional right to bail state, if it's a capital offense, then that goes off on another trajectory. Of course, we make very light use of our capital offense or capital crime statutes in Montana. And so virtually all of the cases are going to go under the non-capital offense analysis. And so this is the Montana specific inquiry. Our default is always going to be the least restrictive conditions of release, but, and here's the but, so Montana has added 3 categories of offenses that get special treatment. And so it's almost like we have the PSA, but we're going to do something different with some specific offenses, and that is the serious or violent offenses. If we have that case, then we can deviate from the matrix, and I'll show you the matrix, and impose bail, okay? So it's kind of like bail reform, but with our own twist. We're never getting rid of cash bail, as I said, until unless we have that constitutional right to bail. If we have a second or subsequent DUI in Montana, you can do some additional conditions of release. And then domestic assault or strangulation is also treated differently. And in those cases, the expectation there will be at least active pretrial monitoring. And this is regardless of whether your PSA score comes back as low risk of flight, low risk of reoffending. We're going to carve out some of these offenses and also allow for additional release conditions. Okay. Almost done. This is the matrix created specifically for use in Montana. And there you can see the levels. You see level 1, level 2, and then you get level 2. And this has to do with, okay, these are people we're going to release, but we're going to put more and additional conditions, and that might include cash bail, and it might include additional monitoring. So this is the matrix that those pilot project counties are using. And here's, we don't have more recent data on this, but I'm just going to give you some figures on how this is played out, the use of the PSA and the matrix in the pilot project jurisdictions. 80% of defendants were released, 20% were detained. Of the 80% released, 60 were OR'd, released on their own recognizance, but 40% had cash bail imposed. So we, if the point of bail reform is to get rid of cash bail, that's not how it's playing out, at least under this approach. I'm not saying it should be, but for some people, that is sort of the holy grail, right? Get rid of cash bail. 88% showed back up, 82% did not reoffend. And within that, only a small percentage reoffended with a violent offense. But we did have 20% detained, and they were at different levels. So most of them, where I showed you that matrix, were in that level 3 sort of, as I said, even though their PSA might have come back as low risk to reoffend or to abscond, because of the nature of the offense, those particular offenders or defendants were subject to higher and more stringent conditions of release. Okay, I got to stop talking now. That's the framework. And now I'm going to turn over to Laura I'm going to stop share to tell you about our survey and how that all works together with what we know about Montana.
Okay, give me a second and I'm going to get my slides together. Hang on. It's supposed to go smoothly, but then it doesn't, right? Here we go. So this should work, I'm hoping. Hi, everybody. Nice to see you. I'm going to talk very quickly about the survey that we conducted and some of our preliminary data. We kind of are slowly collecting the data and going through the information that we have. So I'll talk to you a little bit about what we know so far and our next steps for what we plan to look at, and maybe seek some input as to other things that we might want to investigate with the data that we have. So to start out, through the Office of the Court Administrator, they sent a link to a survey to all judicial decision makers in the state of Montana at the end of last year. So it went out to about 110 people, and this was a Qualtrics survey, so everything could be done online. Our response rate was a little bit lower than we had expected, maybe because we sent it out right around Thanksgiving and Christmas, which is probably not the best time in retrospect to be sending out additional work for people to do. But so of the 110, we got about 68 responses, which resulted in about 50% completed surveys where we had usable data. And the breakdown was, roughly half district court judges and half kind of other judicial decision makers, with a few people who didn't indicate what their position was. So that's kind of the breakdown of what we did. I'll talk about the survey itself in a second. In terms of those 56 folks who did respond, there was a range in terms of their judicial experience, although kind of broke it down into 3 levels. About a third were fairly new on the bench, a third kind of mid-career, and then a third had been practicing as judges for more than 10 years. About half of all of our judges estimated that to characterize their own population as rural, about a third as urban, and then 18% kind of defined it as a mixture of urban and rural or other, which they didn't feel like they could be in either of those categories. Typically, it's about half and half decision making for felonies and misdemeanors. And then there was some variability in terms of how often they're making these pretrial decisions. So about a third are making very few pretrial decisions per year, while we have, half of the group is making between 5 and 20 of these decisions per week, and then 18% more than 20. So it's kind of a substantial number of decisions over the course of their regular week. In terms of the survey, because we were respecting how busy judges are, we had a lot of questions that were yes, no, or simple kind of Likert scale, quantitative questions with a little bit of qualitative, space for narratives to throw in there, with the idea that this survey was a preliminary source of data that we would then attempt to follow up with phone interviews, where we could elicit more subjective and narrative forms of data for those who are willing to participate. So it was a fairly quick survey. It's about 20 questions with some decision trees. So if you answer yes, then you'd be, given some additional follow-up inquiries. And we had a few main areas of assessment. One was asking just generally about what their role is and how many cases they, of these types they see in a week, and what they, perceive as their population density and rurality and so on, as well as looking at the factors that they consider when making these pretrial decisions, and also when they're setting bail or financial conditions of release. So giving them a lot of options based on the mandatory and discretionary factors that are written into our statutes, as well as other things that might be considered. And then specifically, we wanted to look at their history of use with the PSA and their thoughts about it. So why they use it, why they don't use it, what they like about it, what they don't like about it, to get an idea as to how actual judges are considering this tool. Unfortunately, there's always issues when one does research, and for reasons that are beyond at least my understanding with Qualtrics, some of the questions weren't visible to all of our participants. And we actually had a number of questions related to how COVID had changed their judicial decision-making, which we were interested in. Unfortunately, the version of the survey that went out didn't include that. And then there were a couple of other factors that were somehow invisible. So we had to take that into consideration when looking at the data. And I'll kind of point that out as we go through. Okay, so, and you can kind of get a sense over here. This is what the screen looked like in terms of asking about, let's say, so the MCA is the Montana Code annotated. So asking judges what factors they consider when making these pretrial decisions, and they use this scale of 1 to 7, 1 being very little and 7 being a lot. And you can see we kind of categorized it into different types of areas to look at. In terms of those factors that judges rated as most important, or the most weight that they give, the highest was whether the current crime involved force or violence, with a mean score of about 5.5. This is out of 7 on a scale of 7, so pretty weighty. Other factors, all of these were above a 5, above a mean score of a 5, were prior failures to appear, previous convictions, ties to the community, the individual status on probation and parole when they had a new offense, and the mental condition of the defendant. So those were kind of the top, I guess that's 6 rated factors or weighted factors of about 15 or 16 different options. In terms of things that were weighted fairly low, gender, and you can see that's about a 1.8 on a scale of 1 to 7. So gender was not a typical heavily weighted factor, as was age or the availability of property as collateral. So judges were pretty clear in saying that those were not considered as much as the other factors. In terms of discretionary factors, so they again got a similar looking question, but this has factors that are not enumerated as mandatory, but are things that judges may wish to consider when making these types of decisions. And the highest rated here was a PSA score. So I think that the people at Arnold would be happy with that particular response, given that that's theoretically what it's there for, is that it's supposed to be given pretty significant weight. Other factors that were considered to be important by these judges were prior court appearances. So it looks like his history with this particular defendant, the availability of supervision and services on a pretrial level. So this is a resource issue that, you know, Jordan was talking about, whether they have other pending cases in the same court, and whether there's specific information that victims provided that might be helpful in terms of making these decisions for release. In terms of lowest, things like juvenile record and military service were rated fairly low. Actually, COVID-related concerns were also rated as fairly low, which I think was interesting. It may be that this survey went out, you know, a year and a half after COVID kind of started. And so if we had asked this maybe in April and May of 2020, we might have a different response than in November and December of 2021, but just something to think about. So we also, you know, assessed for other factors that people might indicate, and there wasn't really any consistent things that we had missed in our potential options. In terms of use of pretrial risk assessment tools, about a third of those individuals who responded reported using the PSA from Arnold, which is not surprising given that about 80% of the population is of Montana is kind of under these courts that use this tool. So about a third said that they used it, and they've been using it for kind of up to 3 years, just depending on what jurisdiction they were in. So, you know, in terms of their experience with the tool. We asked what their main reasons for not using a tool were. About a third indicated that they just don't have access to that tool. So they could be in a jurisdiction where it's just, they're not part of this pretrial program, where they're not given the tool itself and then the infrastructure in order to be able to use it, which includes, you know, personnel and technology and so on. About a third indicated a lack of resources related to the use of the tool. About a quarter gave some pretty clear negative views of a tool, including that it doesn't provide info, that it's useless, that they don't know what it is, or that it seems irrelevant to their particular task of making these pretrial decisions. And then about 5%, which is 1 or 2 individuals, said that they just choose not to. We were also interested in finding out how often, you know, for those individuals who do use a tool, whether they diverge from the matrix or the decision matrix that's recommended by the tool. And what we found was that, you know, there's some degree of folks that will occasionally diverge, and then a very small percentage either often diverged or never diverged. So it seems like it is used primarily, but there are instances where their own judgment kind of supersedes that of what the tool would suggest they do. We asked specifically about different types of information that might cause them to diverge from the recommendation of the tool. I'll give you some of those other factors in a second, but usually it was related to personal information that wouldn't have been incorporated in those 9 factors of the PSA. So personal knowledge about the defendant, about the family of the defendant, about the culture of the community, and then a resource issue, right, in terms of whether they have access to particular types of pretrial supervision resources. Other factors that judges indicated would be looking specifically at the nature of the offense charged, which I think goes with what Jordan was saying, that we have some of these areas where we are we can deviate from those recommendations based on specific types of offenses. Their perceived level of danger to the community. So this is the judicial perception versus what the tool would recommend or perceive. Believing that these are not reliable, whether there's additional information that's not incorporated in the algorithm of the tool, whether they don't get to see the data, or whether they see the score, but they, in their own personal judgment, believe it to be not an accurate representation of the individual and their risk. And then we asked what the potential or views on their benefits of the risk assessment tool that they're using. And we gave them a number of options. So these are not kind of narrative. We gave them the options of uniformity, ease of use, transparency, efficiency, consistency, comprehensiveness, and evidence base. And the top 3 responses that judges chose were the evidence base, the consistency, and the uniformity of the tool. We gave an option for them to enter kind of narrative ideas as to other benefits, and they said that it appears more objective to them, or that it considers information that they might not have otherwise considered. We then asked what would increase the likelihood of tool use. So again, if you remember, about 1/3 of judges reported using the PSA. So we were curious, again, not having skin in this game, whether people use it or not, but if there were things that would increase one's likelihood of using a pretrial risk assessment. And the top responses, again, these were out of options that we gave. Is more information about the tool itself, more training with respect to how to use it, having a tool that were specifically designed to Montana, given that we have a rural and indigenous population that's not often considered in the data for the creation of such a tool, or absent a specific tool to Montana, at least having data that validates the use of a more general tool with respect to some of Montana's unique properties like rurality or ethnic makeup. So those were our top responses. We did, again, leave an opportunity for judges to give some narrative responses, and the themes were fairly negative with respect to their views of the PSA. And I think this, I hear this a lot as an academic who was also in the court system, is that, academics are viewed as not really knowing what they're doing because they don't have these practical experiences. And that was mirrored in some of the comments, that they're viewed as inaccurate, that they have limited utility, because again, Montana courts are so variable depending on where they are in the state. And then lastly, just having a lack of resources and availability to implement them. I think that's it. That was a very quick and dirty discussion of what we've looked at so far. Obviously, we've got lots of data that we're interested in examining, and I would look forward to hearing if anyone has ideas as to what else we can kind of look at. One thing we want to start looking at is more, I gave you a lot of descriptive statistics, but looking at whether decision-making is different in these urban versus rural judicial districts. So if they weigh different factors, if they have different views about characteristics that they consider when they make these pretrial decisions, if they have different views of using an algorithm or a tool compared to using their own kind of judgment. And then again, looking at differences in decision makers for those individual judges who were using a PSA versus those who aren't. Has that changed their view and weighting of different factors or how they make their decisions? So that's kind of our plan with the data that we have from the survey. In addition, as part of the survey, we asked if the individuals would be interested in participating in a follow-up interview. And so 26 respondents indicated that they would and provided contact information. So our next step in the research process is to conduct these individual phone interviews where we can ask a number of follow-up questions. One of which I think will be really nice is just asking whether there were specific COVID-related changes in their decision-making. I think that would be really useful data to have. Also asking about if and how they collect data on how they make decisions, what the decisions are, and whether they track how that individual fares in terms of showing up and or accruing new charges. Their general view on risk assessment tools and some follow-up questions based on the questions we already asked, access to resources and the use of resources in their jurisdiction, and then asking about any other issues that might be unique to their jurisdiction that we haven't thought of and that impact their job and their pretrial decision-making. So that's kind of where we are. I understand that was really quick, but we look forward to getting some feedback on your thoughts on our current data and what we could do in the future with respect to the data we have and or the data we might collect with our interviews. I'm going to attempt to kick it back to Jordan, who I think is going to run point for some final thoughts and questions.
Yeah, thanks, Laura. Actually, I was going to kick it to Malia. In terms of one thing that we were hoping, as I said in our introductory remarks, this is very much a work in progress and very specific to Montana, but I think with some application to jurisdictions like us. So we would love to hear from folks if you have thoughts, observations about how to get at those deep questions about resources and relationship in decision making. It's a hard thing to get at, so we would love to know if you have, well, answering questions, but particularly on that score, if you have thoughts about how to get to that sort of data.
So I'm happy to, if people just, I think everybody just raises their hand, or this is a small enough group that I think people could actually just put on their camera and speak up if they wanted to ask questions at this point. I actually have a question about the 2 years of data you were able to gather. You had those statistics on, the percentage of people released. And for those, or do you have those? I don't need them, but do you have them by charge, out of curiosity, particularly given that the subsequent data showed that kind of charge seemed to dominate the thinking?
So that's a great question. Just to be clear, that was data gathered by the OCA, by the Court Administrator's Office, and reported to the legislature last year. So we didn't collect. I think the challenge they're facing is that data collection piece. Is they're implementing this program, but we have court systems using different technology, different databases, different everything. And we just, like I said, we don't even know who's in our jails. I can tell you who's maybe in our Missoula detention facility. Mm-hmm. So this is the issue that they're confronting, Lee, which I think is such an important one, is they collect this data. And I think what it's showing is that, as just exactly as you said, and as Laura pointed out, it really is the nature of the offense that is driving the bus. But I don't know the answer to that specific question. But it seems from that, when you combine it with what we found out, is regardless of PSA and the intent behind it, it really very much, and we have our own matrix, which counsels judges to really take into consideration the nature of the current offense. And that's the wicked problem in bail reform, is that people are being charged, they're accused of an offense, but it's the offense, they haven't been convicted of an offense, but it is the charge that is driving that detention decision, even though at least nominally you are presumed innocent. So that is the tough question, right?
Yes, I have more, but so do other people. So I'm gonna ask Kenitra to unmute and go ahead and ask her question. Then I saw a couple other people turn on their cameras, and I assume that's because they have questions.
Malia, feel free to follow up after this. It's just to answer Jordan's first question about how you get at these deeper concerns or these deeper questions about what other factors these judges may be using to make these decisions. Your presentation, and Laura's especially, showed a preview of your actual survey itself, and you look like you had the, you made it as easy as possible to answer the survey. I think it was so that you can get a higher response, but as you follow up, has there been any resistance to actually doing more qualitative surveys and coding more qualitative surveys, as opposed to looking at it or providing a yes, no, or scale the list? Is that a possibility of providing an open-ended survey tool that can then be coded qualitatively?
Well, I'll answer that.
I'm looking at you, Laura.
Okay. Well, our plan is to have these qualitative interviews. So we do have 25, 26 judges that are willing to talk with us and get that deeper information. Obviously, I wish that number were closer to the 110 individuals who would potentially be a source of information. But my guess is that we could probably have future waves of surveys and or qualitative information that we can get at that. And I think that's a good point, right? Our initial kind of round was quick and dirty. How do we get in there and get some basic information and then kind of take it from there and figure out what our next steps might be that are more in-depth or qualitative.
Simon, did you have a question?
Yeah. Hey, just real quick. I'm a social worker at the Public Defender's Office in Billings and in Montana. And just when I was listening to the presentation, I wonder if you've discussed or considered expanding to juvenile matters as well. I mean, I know in Montana that, well, everywhere juvenile cases are civil, but still use a lot of the same, they have an assessment, at least in the 13th Judicial District, they use a risk assessment when looking at pretrial release. And I think a lot of the topics that you highlighted could really apply to the DJ cases in the state. So just wondering about that.
Yeah, that's a great question, Simon. Thank you. And hi. So yeah, as you know, like for whatever reason, it's much more uniform in the juvenile system. There are actually, and I know some of our colleagues over in sociology have done work with the Office of the Court Administrator and the department, and juvenile judges to try and standardize that. And so I don't know as we've thought about adding that per se, and part of it's just because there's just two of us, and as you said, it's a different system. But I do think that would be a worthy comparison point, given that the juvenile system in Montana has been using a standard tool for much longer, and that might help. And a lot of times, as you know, it's the same judges, right? Who are doing it. It's not like we have dedicated juvenile judges in Montana because we don't have that many judges. And to your point, too, as a follow-up, one thing that we would like to, and we've been thinking about, but again, because of our limited resources, is including defenders' offices and prosecutors' offices. In that one question, Laura mentioned that Qualtrics, and it was on Qualtrics's end. I just want to make that clear. So it wasn't on our RA's end, and certainly not in the structure of the Qualtrics survey itself. Dropped some questions, and one really important question we had in there was the length of the ability to pay hearing. Because in Montana, as in other jurisdictions, you have to have an ability to pay before you impose financial conditions of release. And that's something we were very interested in too, and finding out from prosecutors and defense and the judges, to the extent there's different perceptions of what's happening. And so the answer is yes. I think that would be a very valuable comparison to the juvenile system, and then taking another step and including other people who are part of that pretrial detention framework. And that's just, as I said, it's a matter of time and resources to get a much more holistic perspective, of what's actually happening at that process. Simon, your question, to your question though, do you perceive that it's much different in the juvenile sphere than in the adult sphere?
I think unfortunately not. I think a lot of the judges are really aware of, the spirit of the, Youth Court Act later in cases, but, at least in my experience and observation, don't take that into consideration at, detention hearings, especially given, that there's even fewer juvenile facilities, right, than there are adult facilities. And, a couple of the points that you made about, indigeneity and border communities, which I'd argue Billings is.
Yes, it is.
Judges expect families and youths to succeed based on release conditions, in Billings, where, the crime or the alleged crime may have taken place in Billings, but the community's, 70, 80, 90, 100 plus miles away. And I don't think the risk assessment takes that into account either. At least they use the D-Ray, the DR AI score here.
Right. Yeah, thank you.
Can I ask a question, Jordan, just about process? So you said that the bail that you're looking at, is that determined in that initial appearance that you were addressing where there is no right to counsel? And if they have I mean, what you just said kind of fascinated me, that there's also an ability to pay component. Does that come after at like a subsequent review hearing? Is there a lawyer for that portion?
So here, I think it's a great question. So here's again where the rurality piece comes into play. In some of the larger jurisdictions, there will be a public defender just there. There's one down at the detention facility in Missoula. So as a practical, yeah, but you don't have a right, statutory constitutional right to counsel at the initial appearance. In some of the larger jurisdictions, there's just somebody there, you know, who is assigned to that calendar. And as a practical matter, in the more populated jurisdictions, you do have an attorney available, but the pretrial detention decision has to be made at the initial appearance. It can be revisited later, but that's the initial decision point where you have very little information. You don't have a right to counsel. And a lot of our judges may default to the bond schedule. We asked them about the bond schedule. I'm not sure we got good data on that, but we do have a bond schedule in Montana that, you know, lists, like in other jurisdictions, lists the offense and the presumptive bail amount. And so, yeah, that bail decision is made at that initial appearance. And now you can come back and re-argue it and reopen it later.
Yeah.
But, you know, once it's made, it can be hard to undo it.
Yeah, well, and I mean, I do a lot of work around fines and fees in addition to indigent defense. And one of the things that I've figured out is that in these, and it's interesting that we call them right to bail states, and I get it, not right to reasonable bail. Very quickly, what sounds like it's a good thing in a kind of ability to pay determination actually becomes about where you can set bail to ensure the person can't get out. Right, which is like turning the whole thing on its head. And that's why I asked that, because it would be very easy, if that's happening at initial appearance without counsel, to have this thing, which sounds like a great thing that I personally have fought for in other jurisdictions, to get turned completely on its head and be kind of anti-release. Melanie and then Jia-Chen. So Melanie, you want to unmute and ask?
Yeah, so I just wanted, I missed most of the presentation, so I'm sorry. But I wanted to let you guys know, and I'm sure you already know, Rurality County OPD has been working really hard to fight pretrial supervision. And I know Jason Silstrop wanted to be on today, but he is going to reach out to you guys because he kind of has been spearheading the pretrial supervision issues. But we are finally able to get a civil case going on that issue. And we just kind of wanted to let you guys know in case you didn't know.
Yeah, thanks, Melanie. It's good to see you. Yeah, I do know about that case in Rurality. And Malia, if you send me an email, I can send that to you. And it has to do with setting financial conditions of bail such that they are unreachable. Yeah. And so our statute in Montana, what we have is a statute that says anytime a judge is going to set a condition, a financial condition, they must have an ability to pay hearing. So it could be sentencing, it could be bail, anytime there's money involved. And of course, the constitutional overlay, Bearden versus Georgia, says it has to be meaningful, right? And so if you were to attend some of the bail hearings, particularly as Laura said, we have judges who are making a lot of them every week. Some of them last a minute or two. And anytime there is money, there is supposed to be the meaningful inquiry about, can you actually pay this? And how does that even happen if you don't have the right to counsel? And I agree with you, Emily, that what should be a very robust hearing is probably not getting the attention that it deserves, particularly in that initial space where you're just saying, okay, we're going to set bail. And I'm not sure how many questions, if any, are asked about whether somebody can actually meet that condition, that financial condition.
Yeah, well, it's probably obvious, but I would love for you guys to explore that in your interviews. And I don't know how you would code, like whether it's a good ability to pay or not, but timing is one. How long do they usually take? And also maybe something about what the inquiry is aimed at. My experience is that when judges there's a remarkable number of judges who will tell you that they are looking to set bail so that people can't get out.
Yeah.
And they will just tell you outright. So you may find that. Jia Chen?
Oh, hi. I'm Jia Chen. I work at the Deason Center with Malia. I was so interested in this, when you have, let's say if you have bond, a bail set first, and then if you get reopened, does it go in front of the same judge? And do you have any statistics? I'm curious as to like if the bail get reduced or be put on personal recognizance if, like say a PD gets appointed later.
So it can depend on who makes that initial, right? Who makes an initial bail determination. Sometimes they go to a justice of the peace and then later move to another judge, but often it can be the same judge. And if bail is going to be changed, it's usually because a lawyer gets involved and can gather information and say, well, they have a place to stay. They have a cousin who can keep an eye on that. You know, it's that relationship and that resources and the information. And that's usually when you're going to see, it's usually the default, right? If we don't know what else to do with somebody, but we're worried that they're going to commit another crime. The easy thing, as Malia says, to set bail so they can't meet it and then wait for that information void to get filled. So, but we don't have specific date on that, but, you know, honestly, we have so few judges in Montana, it's usually the same judge, right? Who's making the same decisions, because they're just, it's not like we have a huge stable of decision makers. At most, there's 110 people making all these decisions. Yeah.
I know we're tight on time,
I was
but I
gonna
have one
say,
more
we're-
question. Yeah, we're right up on the end, but I have one more
Go ahead,
question.
Khadija.
And it's just from personal experience with everyone. There are a few people who work in Montana on the call. And so, and it was mentioned at the top in Jordan's presentation that oftentimes you may not live anywhere close to the county courthouse or where you be doing this. And you also mentioned that it's usually the nature of the offense driving the bail decision. But is it infrequent to see, or do you see judges making decisions based on where they know a person may live and their ability to get back to court to make their court dates? Do the judges keep people locked up in pretrial detention because they know or have personal knowledge that they might not make it back if they release them? Does that sound, or like you live in a town and get snowed in, so I'm going to keep you in jail because your town gets snowed in and you can't get to court?
So I think that's a great question, and that is something we want to follow up on. So it can be the reverse, actually, where I have talked to judges who said they release people because they don't have a sheriff available to transport them to the next county with an available jail bed. So that can actually work in people's favor. And then I'm going to end with what I think is a really great story, just about the creativity and resourcefulness of rural judges. So one of our judges up on the High Line, who had the experience of being a public defender, which I do think helps to have been a prosecutor, public defender, so you have a better sense, or just knowing your community. And she was going to release a defendant, and the prosecutor, who was not familiar with the local community, was really upset and said, "You're going to release this person, and there was a potential threat to another person." And she said, "Do you even know?" And it was actually an address on a reservation. She goes, "Have you ever been there?" And the prosecutor said, "No." She goes, "Yeah, by the time he gets to the next house, the GPS monitor will go off." She released him to his brother because she knew the physical distance literally between places, that there was just no way this person could get from point A to point B in enough time to make any trouble anywhere because of how spread out the residences are. So I think that's the important thing, is knowing, having judges who really understand the community, because sometimes that can work in a defendant's favor. And just not having resources and having big distances. But the flip side, of course, and this is a hard thing to get at, is if you do have judges who have perceptions, particularly in our border communities, about Indigenous communities and about Indigenous youth and resources that are available. So maybe it's an education piece. that, and we do see that we have huge disproportionality in Montana, huge. The indigenous population in Montana is, we'll see, it's roughly 6.7%. Our male state prison is about 25%, and our female facility is 33% indigenous women. I mean, it's just like crazy numbers. So Kenitra, to your point, I think it can work a lot of different ways. And so I think we're interested is how can that work in a more positive way, right? How can we leverage rurality and relationship in such a way to reduce those numbers and hopefully get at that disproportionality piece, which we haven't touched a lot on in this presentation, but it's a huge, huge issue, not just in our community, but if you look at Wyoming and the Dakotas and Alaska, you're going to see that same sad and very telling statistic is that bail reform, to the extent it's working other places, is not having that same impact on some of those really incredibly disproportionate numbers. So that was a long answer, but I think it goes both ways. Like knowing your community and knowing defendants can be a good thing, but it also may cut against defendants' interests as well. So.
Well, thank you so much, Professor Gross, Dr. Kirsch. I hope you will come back after you have done your interviews and tell us how they went. I don't envy your coding challenges because I have seen judges in exactly this type of rural place. It was not Montana, and I will not disclose the place, where, quite opposite of what Kenitra suggested. I've seen them actually be willing to detain people who were homeless in winter because they knew a storm was coming and the people didn't want to be released. So I've seen people detained on very minor misdemeanors for very intentional reasons. And I don't even know how you would start to code something like that. So I will look forward to the next presentation. The Deason Center's next workshop is going to be our own Pam Metzger talking about her work in progress on charging time. That'll be Thursday, April 7th. Kenitra just helpfully put the link in the chat, and we hope to see you all there. Thank you so much again for sticking with us for the whole hour and a bit. It was great. I really appreciate it. Bye, everybody.
Thank you. Bye-bye.